those things are like 14 or something. Well, you know, I don't think she bothers me. No, I just kind of hate to see him do something.
Hey, welcome everybody. A little out of breath. As this time of year, everybody's needed at many places, and a lot of times the votes are close, so everybody is being asked to be somewhere. So, with that, Representative Bond, what number are you? If you don't mind, I'm going to ask you to open some prayer.
Certainly. Let's pray. Heavenly Father, thank you so much for today. We are thankful for this time to gather together to do the business of the state. We just pray you would give us wisdom and discernment as we do what's best for the people of this great state. In your name we pray. Amen.
Thank you. Just one agenda change. We did have Representative Todd Jones's bill on, but that is not ready. He is still working on it. I appreciate those who have had input on that. So this time we're going to call House Bill 474. Mr. Kirby, if you'd make your way down to the table. Sign-up sheet. Okay, it's down there. Okay. All right, Mr. Kirby, give us a little context before you start into the bill, since this has kind of been hanging around for a little while.
It has, and I think we've talked a lot about the intent of what we're trying to do, and just quickly, just remind, this is all about law and who makes law and making law. It has nothing to do with rules. It has nothing to do with councils. It has nothing to do with boards and their ability. It's just about, it's the General Assembly's responsibility to make law, and when somebody else does it, we've got to have the ability to see how we can fix the problems. So the last version we had was stripped down and very precisely trying to explain the intent where there was anything else taken out of it. So this one is quite a bit different. So we will walk through it. The changes start really on line 39. LC number is 364151S. All right. And we start with the code section that notice of the General Assembly means a written notification. All right, in B on line 43, the rules of the board shall be subject to adoption, amendment, or repeal at any time. The board may adopt, amend, repeal, or make any other changes to a rule whenever such action is deemed necessary, provided, however, that in order for any such action taken to a rule to become effective, the board shall. And then we're going to go down the list. What I have here is also the current board rules, and it says, the rules of the board are subject to amendment at any time. The board may adopt additional rules whenever deemed necessary. However, except in extraordinary circumstances, rule change will be considered and adopted annually to the effective on July 1 of each year. Prior to the adoption, amendment, or repeal of any rule other than interpretive rules or general statements of policy, the board shall. All right, so we're kind of at the same place. The Legislative Council made a few changes in the wording, but nothing that changes what's going on between the current rule and what would be put in statute. What shall they do? All right, 1, send a copy of the proposed rule to the advisory council of the board if such a council has been appointed. There is no statute that says they have to have one. We do have one. We think highly of them. They do a great job, and they should have a copy of it. The current rule under shall says provide a copy of the proposed rule to the chairman of the board's advisory council. So we do add the whole council instead of just the chairman, which I think is we can assume a good chairman would make sure all the members, especially there is a committee, we understand that it recommends rules, but this way we're putting it in the statute that, yes, they're all getting it so they all see it. Again, really no change in what's going on today. At least 30 days, under 2 on line 49, at least 30 days prior to the desired effect of any rule change, provide notice to the General Assembly of such proposed action. Today's rule says to provide a copy of the proposed rules to the chairman of the Senate Insurance and Labor Committee and the chairman of the House Industry and Labor Committee. They got those out of order. The House should always be first, but we won't hold that against them today. All right, so they're going to provide that notice. All right. Then on line 51, 3, hold a hearing on such rule change if a hearing is called by the chairperson of the board, is called by the chairperson of the board, or if a hearing is requested by the chairman of the Senate Insurance and Labor Committee or the chairperson of the House Committee on Industry and Labor, Either committee chairperson may request a hearing within 30 days of Legislative Council receiving notice of the General Assembly electronically. We added the electronic notification. The current rule says, after they provide that notice, at the request of the chairman of the Senate Insurance and Labor Committee or the chairman of the House Industry and Labor Committee, the board shall hold a hearing on the proposed changes. All right. So through all this, we haven't really changed anything from what the current rule says they do. And the question we've asked all along to those that have objected to what we're doing, because they want to answer with this, is say, then what? Okay, the chairman shall have a hearing. That means he's going to have one. But then what happens? There's nothing after that that says what happens. So that's where 474 now goes. All right, they'll have the hearing. We put in some detail. That's for public comments available. Interest parties can talk, submit data, views, arguments, orally written, just standard stuff what any hearing would be in a definition. On line 60, the then what starts. They're going to produce a report. If Chairman Werkheiser says we need a hearing, they ought to report back to Chairman Werkheiser, what do we do? And reports given notice to the General Assembly within 5 days of the hearing pursuant to this subsection. All right. That report shall include a concise statement of the principal reasons for or against the proposed rule change and the action taken by the board as a result of such hearing. Right now, and Chairman McKay, and I wholeheartedly agree with him. He said, if we got notice, that'd be a big deal. He would have a hearing. Well, the rule says he shall have a hearing. But when it's all done, he could simply say, well, thank you for coming, Paul Harvey, good day. We're going to do exactly what we always said. At least this time he's going to give us a written report, and he's going to say, here's the reason we think this is still right. Because if you remember when we talked a little bit, the difference between what could be a rule and what we think is changing existing law or creating new law, it could be as simple as a comma, a word placement one or two times. It is a very small, fine line at times between rules that help administrate the laws that we pass and creating a new law or changing existing laws. So I think, in my opinion, 99% of the time, even if this were to happen, I think we would work it out in this hearing stage pretty easily, because we would, when we object to it, they would know exactly what we're seeing, and if they see it differently, then then we'll continue to work on it. But we get the report back so we know what it is. All right. Well, what if we can't see eye to eye on it? All right, then what's going to happen? Well, that starts on page 64. Basically, if we can't see eye on it, that we're going to make sure they know, and we're going to stay it until the next session of the General Assembly. That is important, I believe, to the people out in the state of Georgia. That if you think about this, if you put something in place on July 1st and we come back in the next session and change it, or say this is no longer applies, we've introduced 6 to 8 months of chaos. And I'm not sure there's any rule that's going to be so important that if it doesn't happen immediately, especially if we're in disagreement on it, that 6 or 8 months of just holding back and pushing that pause button is going to really create an issue. Some may say different, but I couldn't think of anything in workers' comp that I would have that get in there on July 1st that if I thought was too much that we couldn't wait 6 or 8 months till we come back. Now, once we come back, we have 30 days to act, whether it's the House side or the Senate side, whoever was the one that was seeing this. That's on line 76. During the first 30 days of the session, a bill would have to be introduced. All right. Once it's acted on in the House and it passes, it would have to go to the other side, and it actually puts in the statute they'd only have 5 days to act on that bill. So if it started on our side, we'd only give the Senate immediate transmittal, and they would have 5 days to act on it. Now, if this bill were to pass, that would say this rule was no longer, it wasn't really a rule, it was actually a law, and we need to say no to it. If it was a 2/3 votes in both the House and the Senate, it'd be done. That's a pretty high standard. That's the same as any constitutional amendment. It's the same as an override. All right. If it just passes, it's like any other bill, it goes to the governor and the governor's signature. Now, today we have the ability to do legislation to do that now. All right. We don't have the pause button to keep the chaos from being introduced. I don't even know what an administrative law judge would even speculate that if they ruled on this in September and we turned it around in January, what would they do then? I mean, we can't even, if you're keeping up with it, the police officers that cheated on the online training for speed guns, we've got prosecutors now wanting to overturn every one of those convictions for speeding and refund ticket money and everything else. Because anytime you add chaos into the legal system, it's not good. And this it gives us a pause button. It sets a very high standard for us to do it without the governor involved. And of course, the governor appointed the board anyway, and that was going to be that will always be an uphill battle, no matter what side's in there. The governor appoints his board, and his board says, "Hey, we don't like the General Assembly disagreeing with us." Now we know that, but we think it's a good pause button. It gives everybody an opportunity, and I think the few times, and that's the other thing, and that's one of the problems we probably have right now today. I think the council and the board we got today and for the last probably 18 years has done a really good job. They really have. You're not going to hear anybody, having done work comp in so many states, you're not going to hear anybody say any bad about the advisory council with me around. I mean, they just have done a great job. Our board does a great job. We've got a system that's very fair for both employees and employers. And we've said that from the start. I don't know what's going to happen 20 years from now. There are things in our past that showed, okay, there was times we overstepped our bounds. And just to kind of clarify one, because I used a bad example on Representative Park's question on the last thing, when we talk about rules and law and workers' comp. Because I used one of the examples we've been using for things that I think went overboard. But one that's very simple is the posted panel of physicians. If you go to anybody like myself that deals with workers' comp all the time and say, tell me what the law says about your posted panel of physicians, they're going to start reeling off, there's got to be at least 6 doctors. One must be an orthopedic surgeon, no more than 2 from an occupational medical clinical. One must be a minority if one's minorities in the area. It must be posted in a prominent place. This is where injured workers can choose to go for any doctor on. And the whole litany of these things. Now, in doing that, without looking at the book, I think I interjected about 3 different statutes and 2 different rules. But in general terms, if you ask anybody what the law says, we're going to say the same thing, because work comp rules are so important that they are almost as law. And as long as they're helping administrate the law as we write it, they're good. But it's when they start creating new law or changing existing law. That's all this bill's about. I think this is a good pause button. I think it gives a good answer to the people saying, hey, we don't want one person. It's not one person. If we can't reach an agreement, it's 2/3 or at least a majority of both bodies plus the governor. That's a pretty high standard if we say this rule is not a rule, it's law that you're changing. And with that, I'll be happy to answer any questions from the committee on the bill as written.
Okay, we've got several. I want to make a couple of comments. First, to the author, I appreciate your patience and really willingness to listen to so many people. I know this is a really sensitive subject to all sides, and he and I both were bombarded daily since then. And
fortunately, the bus is big enough it can roll over the top without hitting you.
Yeah. So and he was getting so many different suggested changes at one time, so many versions. Toward the final, I asked him if I could see the latest change. He said no, because I want to read it for 2 days without anybody interrupting me. So, I appreciated really the fact that he didn't want information going out that wasn't accurate, but it does go to show you the extent of which he is taking this very serious. He's listened literally to all sides, everyone. And I think part and case of that is where we are today versus where we were just a few weeks ago. One of the earlier versions, some of the comments, I know Sam Parks, Bonner, Carpenter had mentioned, the bar is pretty low as far as this committee that, is made up of people restaurateurs, printing businesses, attorneys, whatever, for us to overrule something that a 110 panel of very high qualified people, that should be taken very seriously. And so earlier version had a bar that you really could just step over without much effort. I think we have a bar now that you got to be a pretty good high jumper to get over. So Anyway, I appreciate that, and I think that bar needs to be set high, and I don't want us to lose the site, because I know there's been a lot of narratives on both sides what this bill does and doesn't do. But I just want to reemphasize that it is legislative oversight and transparency, and that's all. We're not trying to micromanage or show our muscle or any other many things we've heard. So I'm going to start left to right. I don't know who hit what first. Who is number 15? Mr. Parks, go ahead.
Thank you, Chairman Werkheiser. Thank you, Representative Kirby, for your patience. I did have a few questions, if that's all right, Chairman. So just to begin, I know we had a conversation regarding the APA and the need for rules in particular to have for there to be flexibility in proposing rules as being a key distinction between a rule and a law. In this instance, I understand the intent of the pause button. I am a little confused in terms of the timing and how long that pause button would last. Just as an example, on line 72 to 74, if a rule is objected to by one of our respected committee chairmen in either the House or the Senate, it states that the rule would then or may be considered by the General Assembly at the next regular session. So you know, if there's a rule that's proposed by the board, let's say in July or August, the legislature then comes back the following year, would it require an additional year for there to be action taken, at least based on how this is written?
No, and I apologize. And now that you brought that up, and that's a great question. If you look on, starting on line 64 through 66, all right, so they have their hearing, they do the report. The report comes back to us, and whatever change they have made, there's some change, and that's what it says, was hearing is held on a rule change. Wait 10 days after the date of delivery of the notice of the General Assembly before implementing the rule to give us time to act. And if we're fine with what they do after that 10 days, it goes into effect. All right? So we see something that they proposed a rule, and we think this is changing law, and we send them a notice, they have a hearing, they send us a report, and it says, okay, we made these changes, and we look at it and we say, this now helps administer the law as we wrote it, and is a good rule. There's a 10 days to make sure we have time to look at it, but then after that 10 days, it would go into effect. If we still disagree with it and we still think it's law, then it's going to be paused till the next session in January. And it says in here, if we pass it by 2/3, it stops the next day. If we don't act, it actually would go into effect on the 31st day, since we didn't do anything within 30 days. And then of course be effective on the governor's signature if it's something that he were signed, or would be the rule going effective if the governor vetoed it on the next day. And it says that in there on the statute.
So Representative Kirby, if a rule goes beyond a rule, and of course there's vagueness as to where that line is, as legislators, do we not have an ability to introduce a law to address that rule, that with or without this bill?
We can, yes, absolutely. But that's where we put in that 6 to 8 months of chaos, because that rule will go into effect that we think is changing law on July 1st. That's when the board rules go into effect. We don't come back until January, goes through the process here, and then you throw in the governor's time, so you're into May, when was 45 days after we sign, he died to sign everything. So and that whole time's chaos if we pass something that would overturn it.
Is there any concerns of injecting partisan politics into the rulemaking process, that where the advisory board is able to bring together experts, especially if under this code section it would require the rule to be to go through committee and then to have to go towards a 2/3 majority vote in that?
Not really. I don't think so, because we're only talking about the intent's about law, not rule. They have the authority to make rules. We want them to make rules that help them administer the laws as we write them. These are the times, and is it politics when we make laws down here? Absolutely, we know that. But it's lawmaking, and again, the thing that we talked about, one of the things that we talked about, is, and it's somewhat up to our chairman and who the chairman is. We didn't put any requirements for the committee. Would it be a committee vote? I mean, how Chairman Werkheiser may want it if let's say Pedro saw something that he thought was creating a new law, and we all got together on it, and what if he was the only one? Then maybe the chairman would say no. Maybe it's a vote of the committee. I mean, we didn't put in a statute what he has to do or his counterpart in the Senate. If we think that would be helpful and needed, it'd have to be a majority of the committees. We can certainly look at that. We don't want just, Tom to say, this is bad, go away. I might be able to talk the chairman into sending the first notice, but after that, I think the committee would say, we need more input. So,
Yeah, and if I can interject, part of that is, you got to remember this language, and we have our very learned attorney, Sean Marie, sitting in the corner over there. Most of this is pretty standard language for this process because so many other agencies abide by this process. And you brought up a good example, and Chairman McKay is here. I know of 2 times this summer during the rulemaking process where someone called me and said, the rule had not come out yet, but they had concerns. And so I simply called him, and we have a lot of discussions when we're not in session. And I would say, Chairman, someone's brought this to my attention. Can you give me clarity? Because, I'm not a workers' comp expert. And he would explain it to me, and I would go back to the person, either say, look, you might disagree with this, but members of your own group or on the council, they thought this was a good idea. Or I know at least one occasion said, you know what, we're already ahead of you. We've put a pause on that ourselves. And so a lot of times it just stops right there. We have a discussion, and a lot of times it's just communication.
Like I said before, I think the current group, for the most part, it works very well. I can't tell you what's going to happen 10 years from now, 20 years from now, because I know past history prior to this group, we've had issues, and I think some of the lessons we need to learn down here is when we have a chance to correct something and make sure things going in the future be right, we do it when we can, not when we need it, and then it becomes a real emotional trial and all kinds of things going on.
If I may, one more question.
Yes.
I appreciated one of your earlier hypotheticals, just in terms of there being the need for a pause button to, avoid, a rule going into effect that may then, be amended by or overridden by an enactment of law. Are there, or would there be any instances where harm could occur by that pause button, where the rule is not able to go into effect?
Yeah, that's one of the things we talked about, and I mentioned, I went through a lot of the rules in workers' comp, a lot of the things that I deal with every day as an HR manager in workers' comp. I could not think of anything that's in the last 5 to 10 years that's been added into the rules, and I won't do a full comment on the website. There's parts I don't like about it, but the one part they do is by years, where you can look up the rules and what's changed. So it made a fairly easy search. And so I go down through there and look and said, well, they put this rule in, that wouldn't really made a difference. That it had to wait. It does fine with it is. So I couldn't think of anything. If there was something, but I really envision that if there is an issue, I really think it's worked out in the first time, and if it's not, I think we got maybe bigger problems than what we're talking about here today. But we ought to work it out, and 10 days later, it's good to go, and they've got a rule that it helps with the administration of the law as we wrote it.
Thank you,
Thank you, Representative Carpenter.
Thank you, Chairman. Thank you, Mr. Kirby, for your hard work on this bill. I just got a couple of quick questions, because I keep hearing you refer to chaos, and that when they make a rule, it's chaos. And would you say that the state of the Workers' Comp Board now and the Advisory Council is chaotic at this particular moment?
Absolutely not, and that's not what I'm intending when I talk about the chaos. If you had a rule go into effect July 1st and it was changed May 1st, the fact that it's no longer a rule would create the chaos. That they operated it
Okay.
for so long under this rule, and then all of a sudden we said, no, that was creating new law, and we had the votes or whatever, and people agreed. Now the ALJs, administrative law judges, will be out there saying, what I do with the rulings I made around this rule as it was written then versus now. That's where the chaos could come from.
I got you. So follow up real quick. So I probably need a little education. So when they change a rule, what is it? A 30-day implementation period of a rule change? Or is it the next year? How does that? I don't know. That's what I'm asking.
Under their board rules, they propose a new rule. It goes. The rules will go in effect on July 1st. They are required to send a copy to the chairman of this committee and the chairman of our counterparts in the Senate. And there is, in their rule itself, it does not require 30 days, 5 days, 10 days, 1 day. It just says prior to adoption. And the adoption date's July 1st. So
Okay, so they could do it anywhere up till June if they wanted to, and make it in July. And then one further question: how long is the term on the board? So when people get appointed to the advisory board, how long are they on that?
they're appointed by the governor, and I think until the governor. Nope.
Aren't they,
No,
Chairman, aren't they
4-year term is-
6-year terms or 4-year terms?
Three-member board of the State Board of Workers' Compensation are the directors of the board of directors, appointed by the governor to 4-year terms. The board appoints the members of the advisory council to serve at will of the board of workers' compensation.
But when your 4-year term is up, you can be reappointed unlimited times or?
That is correct.
Okay.
Yeah.
and so the advisory council, they serve at the will of the board, no select time, correct?
Correct.
Okay, so if Roy gets on your nerves, you just
Yeah.
tell. I'm just kidding.
He gets a letter.
That was a joke, folks. But so I think you know kind of where I stand on this, but my concern is there's a lot of things in the state of Georgia that we need to work on, but when we've got something that everybody in the nation looks at as a model, I have a hard time interjecting the change, because just like anything, it's a slippery slope. Today we pass this piece of legislation and it's 2/3. Next time we come in, we change it to just a simple majority. I think that it's a slippery slope as you start to change things and it becomes something that we don't intend it to come. So that's just my thoughts.
Okay. I believe Ms. Gilligan was up next. Representative?
Thank you, Mr. Chairman, and thank you so much. I was about to call you Tom, Representative Kirby. Thank you so much for bringing the bill. I did have a couple of questions, though, if you don't mind, and I'm trying to remember, since I don't have the legislation that we were seeing before in front of me. If I remembered right, before, if it was a substantive change to a rule, then it would have gotten the 30-day. But what I'm reading now, it seems as if any change, whether I'm amending, appealing, adopting, doesn't matter, any rule that I am proposing or changing would be subject to this submission to the chairman and then the 30-day delay before it could be implemented.
I'm
just reading 40 lines.
Okay, I think I can
43.
answer that. I don't think there's two classes as far as change. It would be like legislation. Every rule is a brand new rule. Now, if they're changing a previous rule, it's still a new rule.
Right,
that
and
correct?
every single one of those would now come to the legislative branch through our chairman.
Well, they're
And
just
then
submitted to us.
They're
Correct.
submitting to us, and either chairman then at that point could object to any one of those, not just because.
Yeah, that's the current,
I've
and
heard
that's
your
the current.
words.
That's the current board rule. Any rule
Yeah,
that
we can
they
do that now.
they want to put into place is supposed to go to Chairman Werkheiser and Chairman Jones in the Senate, and they have the ability, as it says in the current rule, to object to it, and then that's when the chairman of the State Board of Workers' Comp shall call a hearing on
Okay,
that.
what am I buying in this? What's the difference I'm making?
The difference
than if
is
I'm
the
doing it now?
process. If we go deeper and want to pause the rule. There is no process unless someone drops legislation. So this basically is making it more consistent with most of the other agencies. Giving you a good example is when, some of you younger folks, we've got a very robust craft brewery industry in Georgia. That was not the case 6 years ago. So the legislature did legislation to change that. And this is what we had envisioned. The Department of Revenue, through rulemaking, pretty much undid what was the will of the legislature. And so then it begins the process of what to do.
Right. Okay, so
And
understanding
right
that
right
they're-
now there is no process other. They have a hearing. We're done. We can say we had our hearing. Nothing has to happen. That's why I say the then what. Their rules currently don't have anything. There's nothing in the statute. There is nothing other in a rule that says, hey, we have to have a hearing. We had it. Go away, legislature. We like this.
Okay. Whatever became, I'm sorry, I slept, I guess. We had a presentation and a gentleman stood up there and had a rule that the advisory board was willing to adopt, and it would have addressed a lot of the issues that we had discussed in the original, the original language of your bill. Did that just die?
There, what I think you're talking about, and they can probably sign up to speak later. The advisory council did not come to a consensus on that, and so they didn't have anything to propose. But I will let them speak later on that if they want.
Okay.
We have asked for, and as late as this week, sample rules that do. But again, the last one I got stopped at the same place and didn't have any action following a hearing on what would happen. Now, I got that as early as 2 days ago, or as late as 2 days ago. Okay. And it's like, we're just not going to do anything after that in rules or statutes. So I don't understand why. Because we're not talking, again, we're not talking about rulemaking, even though we use the word rule. We're talking about law. General Assembly makes law. Not a council, not a committee, not a board, not a agency in Georgia. It's our responsibility that we're not going to abdicate to anybody else. And the question is, if you think somebody other than us should make law, then you don't like my bill. Okay. If you think we're the ones that make law, then we're just going to need to argue about the semantics of how do we make this work.
Representative Bonner?
Thank you, Mr. Chairman. So, Representative Kirby, are you aware of any other agency, board, or anything within the state of Georgia that currently operates under this particular standard?
Yeah, about 90% of them.
That requires a 3/4 vote?
Well,
And then-
when you look, the state board's not under the APA. We don't want to put them under the APA. Don't think they need to be there. But 90% of the agencies are under the Administrative Procedures Act. The same type of process goes in place. I'm not sure the 2/3 votes in there. I think it's just a simple majority and goes
Right,
to the governor.
which
But there's
which
also
furthers the argument is that we've made the bar even higher than what most agencies have to do. Because, in fact, that kind of speaks to the confidence that we do have in the current system, is we want the bar to be very high before this body can enact a change.
I guess just a part of my own challenge with this is that we enable these boards to compose themselves of experts and folks that are a part of the various industries involved, and we empower them to basically come up with rules that provide for remedies and relief and things like this within those industries, within this realm. And yet we want, it's seemingly through this, we want to kind of reach down into that and provide what I see as a little more than oversight, but actually kind of reaching down and actually doing the job that we seemingly have empowered them to do.
I don't see it that way. I don't think we're not advocating and don't want to get into rulemaking. That's not our intent. Never has been. I mean, that's one of the problems we've faced through this is we've had people that are behind me could keep talking about it's not our job to make rules. We don't want to make rules, and that's the same thing that happens with every agency under the APA. Are all these, and the same thing we saw with revenue. It's not about making rules. It's when all of a sudden we see somebody changing the law instead of just making a rule that administers the law as we wrote it. All right. We're not looking to make rules, don't want to make rules. But when we see this right now, we have nothing that we can do other than waiting, 6-8 months to come back and drop legislation to change it. And the issue with that is you're still going to go to a governor for a signature or a veto that appointed that board. That board's going to go to the governor and saying, hey, we need you to veto this. I mean, we know that's an uphill battle. I mean, it's really not practical to say that option's going to work most of the time. It just isn't, and I think we all know that. I mean, we're all down here to do what we think's for the good of the state, and the governor is too. But that's why they appoint their people in these positions, that they have confidence as well, and they're, so it would be difficult. We know that.
And I think one of the challenges that would make this agency a little different if, let's say, DNR did rulemaking, and it was 6 or 8 months later that a change was made by the legislature. You don't have actual work comp cases that all of a sudden are entered into the system. So then what do you do with that legally? Do you have 3 sets of criteria before the rule, during the rule, after the rule, or after the legislative change? So, and I guess that goes back to the chaos question. Is that it? Okay. Thank you for being patient. Representative Hawley.
Thank you, Mr. Chairman, and thank you, Representative Kirby, for going back painstakingly and at least trying to negotiate the wording to where it can be fairly pleasing. I think, one of the things reading through this and how it is certainly different from the previous rendering of this, I wanted to know if you could help me to kind of be able to see it. I know that you're pro-business, but at the same time you have a human resources background. Usually when we're considering having to change the law, it's seeking to address a problem. And I know that you said just in your presentation here that, it's best to do this now because, yes, further down the line you might not be able to see it. And yet you've looked over the past in the context of within which the board has been able to review these cases, and you've said that, that it's changed. The rules have changed to some degree. Could you maybe just be able to expound a little bit more on that? Because I want to just looking at this oversight in terms of just a general review, as we know that's at least I tend to believe that that's a good thing for democracy alone, just in terms of the transparency. But what is it that this is particularly, have there been any, not necessarily harms, but things that have occurred previously that this is seeking to address?
Yeah, and thank you for the question. What's happened in the last few years, like I said, we can praise this council and this board and what they've done, but we can also go back not that far back and start looking at some rules. 200.2 is an example. And I'm not sure I would say pro-business. I want to take care of my people too. So that is extremely important in work comp to be balanced and fair. 200.2 is what allows for a nurse case manager to get involved into the every detail of a work comp case, dealing with the injured worker and the doctor and meeting with them and in the exam rooms at times and the whole bit. There's nothing in statute that puts a work comp or case manager in there. I think to me, that was one time I think And though a lot of people say that's employer friendly, I think there's a lot of times that I don't see where they came up with that. They just decided let's put a nurse case manager in there. We've talked a little bit about the 240 rule, and that deals with returning somebody to work on light duty. If you read the statute, the first paragraph that is passed by this body, and in that paragraph alone, it says, if the go to the doctor with an injured worker, and the doctor says, he can work some light duty, and the employer says, I got that light duty that meets, then he can do it. And if he refuses to do it, then he doesn't get the indemnity benefit or paid for lost time. Well, then there's some more wording below that. I understand that, and not here to argue and get into detail. But as I read through all of it, what we do now is there's a 240A form. It's all got to be filled out and goes to and it puts in this whole process that, again, I don't think the statute ever intended to, and I don't think the statute says that. Now those have been around for several years, but I have to go back and tell you exactly when. So there's been some issues in the past, and I know, and there will be issues in the future. And I think there's a reason that we have our responsibility to make law. And when we see something, we got to address it. Can we do it by statute now? Yeah, we can. Will it be an uphill battle? Absolutely. But I think this is a better system that's more in line with what pretty much every state agency has to do. That sets a very high bar before we really mess with anything, because we're dealing with what we think's law. And again, I really, with everybody in this room behind me that I know and talked to so many of them so many times, if there's a disagreement between what we think's a law and they think's a rule, I think 99% of the time we're going to work it out in that first little hearing, and that report says, okay, we changed this word, put a comma in here. I think this addresses what you want. I think it's going to work, but we got to have something in place before we do it.
So, and basically because the threshold is so high, it's
and Chairman Work, he got a call from Chairman McKay. And we're already ahead of you. We saw this coming.
Okay.
And like I said, for them, they do. I'm not going to criticize the job they do. I don't know what's going to happen down the road. And if we have no ability to get involved.
Gotcha. Thank you, sir.
Thank you. Thank you, sir, for working really, really hard. I know you've been working hard on this. I just have a simple question and possible, I would think, a friendly amendment. When you take the section 64 to 71 that addresses if there's a rule and if there's, for some reason, there's no agreement, the rule has to stay. And then section 72 addresses how to address that. On line 74, it says Part B of this code section may be considered by the General Assembly at the next regular session. I think I feel better if you all got to that point that it said shall.
Well,
say that again.
So you would change that on line 74, the first one from may to shall.
Yes.
All right. And I understand what you're saying, but if we don't do anything in the first 30 days of the session, then it's over, and the rule is adopted.
And you got to remember this language. I'm sorry.
So what you're saying is you don't need to change that.
So let's remember this is the second go. There's a rule that we thought was changing law.
Yes.
They had a hearing. They sent us a report. They maybe modified it, maybe didn't. We still don't agree. Okay. That's when you get into line 72. But that's I don't know, time frame. Maybe that could be done by sometime in August. Well, between August and January, let's say, Pedro was the one that was objecting to it. And they sit down with Pedro and they talk and have more discussions. And Pedro said, now that you've explained it that way, I'm okay with it.
Yes.
I don't think we need to do anything.
Right.
So the May says Pedro never drops the bill, come in session, and it's adopted.
Okay, so I'm with you. The thought I'm having is, let's say you all weren't Pedro wasn't representative, wasn't able to
I'm
come
sorry.
to
I
an
apologize,
agreement.
Pedro. Represent.
Well, I know, right?
He keeps calling himself Marin, and everybody knows it's Marin. So you know.
I won't go there today. Using your example,
Yes.
and we get to the end of the year, there's no agreement. We're in session.
Mhm.
And this is May proposed legislation. Then you're saying if the legislature doesn't do anything, because May is there, and the session ends with nothing happening, then the rule that you thought was a lie, I mean was a law, automatically goes in effect.
Actually, on the way this bill is worded, it would go in on the 31st day of the session.
Okay.
Yeah, and remember,
Okay.
yeah,
And,
this
and
this
Representative
is
Marin
vetted.
is agreeing. So
Yeah, and our very
Apologize.
learned attorney back there drafted this from current. So I'd be hesitant to at this late game entertain any amendments because of the other 14 versions we've been through. And
Us having this dialogue cleared that up for me, and so I'm okay with May.
okay, Representative Park.
Thank you, Chairman. Representative Kirby, just a few more questions, if you don't mind, that came to mind. Yes. With the current rulemaking process, is there an opportunity for there to be public comment? Is that rulemaking process open to the public, or is it something only conducted by the advisory board?
Well, since you're looking at me, yes, unofficially, no, officially, only because just like everything we do is open to the public. So if we had a hearing, it would have to be advertised and any interested party would come. And I can promise you, if someone has a problem with a rulemaking, that person would be there. So that's,
And when
yes.
we talk about public comment, and most of our agencies, because of the wording of the APA, have so many days of public comment are required. There is no requirement for work comp on their rulemaking. As you said, hearings are open, but you'd have to know about it and know what's going on. Right now, the process, as have explained to me over and over, is there is a rule committee of the advisory council that makes recommendations, and they go through their process. Again, it's not something that has to be noticed, posted, or 30 days of public comment on. They make their recommendations to the board that then can choose what they do with it from there. But that public comment section like we have under APA does not exist.
Thank you. And then one last question. So in the event I'm at lines 81 to 83. So in the event the resolution is adopted by 2/3 of the votes of each branch of the General Assembly, the change to the rule shall be void on the day. Can you recall the last time there's been a 2/3 vote similar to this?
To override something?
no, and that's why we think the bar is very high.
It hasn't happened since I've been here in 5 terms. So
That's probably a better question for Roy, who's been through 40 legislative sessions. Have you ever seen an override of the? No, there you go. There's your answer.
But I mean, we've voted on a lot of bills so far this year that have gone over 100.
Yeah.
well,
yeah.
2/3. We have 2/3. And my hope is we'd never get there. On all this, I think we work it out in the first step. And that would be my hope and the desire from coming out of this, that we put a then what in there, that something now has to happen, that we work out in step one and everybody's happy with. And 10 days after that, it would be adopted.
Sorry, one more question.
Yeah,
So to Chairman, your point, or your note that about 90% of all state boards and agencies under the APA have that sort of statute and requirements where there would be a 2/3 requirement by the majority of the General Assembly to void a rule. Is that?
I'm not sure about that particular point, and our attorney just left us. I know that because the APA is about 110 pages long, so it's a lot of processes. But I'm not sure about I think the 2/3 is not in there. I think that's what's kind of unique, and especially for some of you who are concerned about us interjecting ourselves in the process. I believe that is much higher than the normal APA, but someone's welcome to correct me if out there.
Thank you, Representative Kirby.
All right,
Thank you, Chairman.
We got 3 minutes till. That's all the questions. We had a sign-up sheet, and miraculously, no one signed up, which kind of surprised me. Was there anybody that wanted to say something? We've got 3 minutes. Okay, Mr. Potter, were you saying? Okay. But make it brief.
Gilligan, thank you for referring to me as that gentleman that spoke before I did. This bill was thoroughly vetted on day 3 of this legislative session. You all had asked last year for the advisory committee response for them to vet that. They did that. They came back and indicated that they felt that this could be addressed by a board rule. I had indicated to you at that time that there was a draft through the legislative committee of the advisory committee. As this process has developed, the state board has indicated their willingness to pass a rule to address all of this that has been discussed, including a 45 days in advance posting on a website, opportunity for input, opportunity for respective chairs to insist upon a committee, to insist upon a public hearing should that be necessary. The board has that right now. I would suggest to you in the bill, this is in the law right now, lines 13 and 14. This is not new. Processes and procedures under this chapter shall be as summary and simple as reasonably possible. And for the last hour, you all have talked about something that is far from summary or simple. I would suggest to you as well that Representative Kirby at the last meeting said a number of things. One of those things he's repeated a number of times here today is that the State Board of Workers' Compensation in Georgia is in great shape relative to the other states that he deals in. He's complimented the advisory committee on many occasions here today and before. One of the reasons that the state board system is what it is because there are 120 folks that volunteer their time to provide that balance. That keeps pressure from being built up over time such that there are draconian shifts through legislative action that has occurred in Florida and other neighboring states. It has not occurred in Georgia in the last 25 years. I suspect one of the reasons is that people in the advisory committee and the State Board of Workers' Compensation actually talk to one another and address issues as they go along. From the perspective of this bill, I would restate what I had stated before. It is the recommendation of the advisory committee that you take no legislative action on this matter, that it can be addressed by board rule, and that the term chaos was used a number of times here today, that there is no chaos inflicted in this State Board of Workers' Compensation thus far, but this may do it. This could inflict some harm on the advisory committee, and I would recommend that you avoid doing that. On behalf of the advisory committee, I would suggest that you not act on this bill. Relative to the APA and the agencies that the chairman and Mr. Kirby has referenced, there are 21 entities that are exempt from the Administrative Procedures Act. The State Board of Workers' Compensation is one of those, has been for a long time. Much of this language is cut and paste from the Administrative Procedures Act. While it doesn't put it under that, it does some portions of that. And from my perspective, it's simply unnecessary. A lot of conversation in the hall over the last month about this, and a lot of conversation here. But in terms of the complexity that you all are trying to wrestle with today, I would suggest to you that it is simply unnecessary, and that give the board an opportunity to pass this rule that has been presented to the chairman and is presented to Representative Kirby. Maybe it doesn't go as far as Representative Kirby wishes on a pause button or whatever that is, but I believe that it will solve whatever the dilemma is in terms of input into the rulemaking process. And that's the quick comment for Representative Kirby.
Okay, I appreciate that.
I'd be happy to
Oh,
answer
got a
any
couple of
questions.
hands raised. All right. Come on up, Mr. Bourne.
Thank you, Chairman Werkheiser, members of the committee. My name is Robert Bourne. I'm an attorney. I practice in Forsyth County. I practiced workers' compensation law for 33 years. This legislation is about checks and balances. It's your job to write the law and to set the policy. It's the agency's job to follow your direction. You've never abdicated that responsibility, and you shouldn't. And with legislation, every year the board will bring a bill in front of you and they'll explain it, and they pride themselves in the advisory council, which is a good thing, and they'll tell you that the legislation is a product of consensus. That's how it works with legislation, and that's how it should work. And we do have a good system, and we do have a fair and balanced system. But that's not how it works with rules. There's no point in the process where they come in front of you and they explain to you what rules they are changing and expanding. This is a product of consensus. Now, 90% of all of these rules are very minor tweaks that are not significant. But some of them are. Now I'm going to give you an example of one. We have in our statute right now a provision for rehabilitation suppliers. And a rehab supplier is kind of like an intermediary between the adjuster and the claimant. Their job is to go to the doctor's appointments, make sure that the claimant is getting everything that they need medically, and when the time comes to help that claimant, assist that claimant back into the workforce. If the employer doesn't have anything, they would assist in getting them another job and possibly another employer. In 1992, we made a change to that statute, and we said that rehab is obligatory in catastrophic cases only. But we left the statute in place for non-catastrophic cases. And the way it worked was both sides could agree to a rehabilitation supplier. And these rehabilitation suppliers are licensed in the state. They're ethically, morally, and legally bound to be unbiased. And either side could fire the rehab supplier. But in 2015, we made a rule change. We introduced case managers. Case managers are under no legal obligation. They have no duty to the claimant. They're not ethically or morally obligated to be unbiased. And unfortunately, in litigation, the first casualty of litigation is the truth. And they can be as biased as they dare. And, you know, depending on what side you're on, you might think that's a good thing or a bad thing. But the one thing everybody in this room can agree to is it's a significant thing. And that's what we call legislating by rules. That's your job, not the board's job. I hope that by passing this legislation that they will want to bring significant changes through the front door when they bring the board's bill in front of you, instead of through the back door, through rules where you have no oversight over these rules. Unless you have any questions, I would urge your favorable consideration of this legislation. Thank you.
Come on up.
Good afternoon, Chairman Werkheiser, Representative Kirby, members of the committee. I'd like to address several of the comments that have been made today. There was a discussion about whether this should be a rule rather than a statute. But part of what is necessary is the involvement of the legislative committees. Do we really think that the board has the power to enact a rule to tell a legislative body what it has to do? Additionally, there was a discussion about the exemption from the APA that 21 agencies that Mr. Potter mentioned are exempt from. What he might not have disclosed to the committee is that many of those agencies have, despite not being under the APA, adopted the very same procedures that the APA uses. They're just not covered under the APA. And why? Because they're very good procedures. Virtually every state agency has published rules regarding the exercise of its rulemaking function. In other words, rules that tell them how to make rules, but not the State Board of Workers' Compensation. The board's rulemaking authority is limited to creating rules that address procedural and administrative matters. They don't have the authority to make policy or to create substantive law, as Mr. Kirby mentioned. Representative Bonner, you mentioned about how the legislature enables advisory councils. You can read every single word of the entire Georgia Code. The Advisory Council to Workers' Compensation is not established in the code. It is an ad hoc organization. Representative Park, the governor appoints the ALJs, and then the chairman of the board, who is appointed by the governor, appoints the advisory council. Unlike so many of the advisory councils that exist in the statute, like the Coastal Advisory Council or the Palliative Care and Quality of Life Advisory Council, or the Alzheimer's and Related Dementias Advisory Council, or the Advisory Council on Rare Diseases, they are established and there are a set number of representatives from set constituencies. Not the Workers' Comp Advisory Council, but nobody's talking about creating a statutory advisory council. Nobody's talking about putting the board under the APA. All we're talking about is a little bit of legislative oversight over an ad hoc advisory council. This bill doesn't abolish anything. It doesn't destroy the advisory council. It merely introduces a little input and oversight from the organization that is supposed to make the decisions about policy and law. It's an admirable first step. One of the rationales that was advanced at a previous session was that regulation of the board should not be external because, after all, the board is a court. So I did a little research. The allegation that the State Board is merely a court is inaccurate. The State Board of Workers' Compensation is a complex regulatory agency. Only a small fraction of its work is actually involved with adjudicating disputes. Proof of that assertion is found in many ways. The board has 11 divisions according to its website that is published. Even if you include the Settlement Division and the Alternative Dispute Resolution Division, only 4 of the divisions of the State Board are actually involved in adjudicating disputes. Fewer than half of the board's 131 employees are actually involved in adjudication or appeals. If you count every attorney and every legal secretary at the board, you still don't reach half actually involved in adjudicating disputes. And that's even if you include every mediator. The board has 42 distinct numbered rules and hundreds of subparts of those rules. No more than 12 of them actually concern themselves with the adjudication of disputes. The idea that this is a court and should somehow be exempt because it's only a court is a fallacy. It is a complex regulatory agency that regulates everything that happens in the field of workers' compensation. Another rationale advanced for the avoidance of external control, which is what we're talking about when we talk about legislative oversight, was that the board is funded by assessments. And because the board self-funds, the legislature should apparently take its hands off. Surely none of the members of this committee are persuaded by the idea that a system, the mission of which is to protect employers and to protect workers, should become privatized law merely because it pays for itself. To accept that premise would be to reject the idea of an unbiased justice system. This bill is the very essence of good government legislation. It gives neither employers nor employees a leg up on the other in workers' compensation disputes. It simply mandates a process of oversight by elected officials who in turn are responsible to the electorate. There are no political controls save appointment by the governor over the State Board of Workers' Compensation. The issue shouldn't be partisan, and it should not draw objection from any stakeholders in the system that value transparency, input, and process. This is a process thing. This is not about one side having a leg up on the other. Thank you.
Representative Carpenter?
Thank you for your time. I didn't catch your name. I apologize.
Alex Wallach.
Okay, Mr. Alex, real quick. I heard you and I listened to you, and I kind of got a little nervous when I heard a good first step, and I think that's what I was talking about in here. About it's a slippery slope as you go to twist things and things change. The intention of the first meeting does not become the intention of the last meeting, and so if you would kind of go through that first step, second step. What's the? I mean, you see what I'm saying? Where are we headed?
Well,
And so if it's a first step, what would you like to see? I guess.
I've never run for office, so I can't begin to suggest where we're headed, sir. Where
would you like for us to head?
Well,
let's get on that road.
To be candid, I was asked to speak on behalf of my organization, and I would not be able to present where I think we ought to be headed on behalf of that organization. I think that more regulation and oversight of the State Board would be a healthy thing. Thank you.
Representative Park?
Mr. Wallach.
Oh, yes, I'm sorry.
No, not at all. I appreciate your testimony. You mentioned at the beginning of your remarks that the workers' comp board did not have any procedures in place similar to the APA, even though 21, 23 other agencies that are exempt have adopted to a certain degree. So is it your assertion that the State Board of Workers' Comp is the only quasi-regulatory agency that does not have procedures in place that permit public comment similar or comparable to the APA?
I'm not sure that it is the only one. Several of the exemptions contained in the Administrative Procedures Act are for organizations like the State Board of Pardon and Paroles, okay? And so some of those organizations would naturally hold their exemption differently than the State Board should. Does that address what you were getting at, sir?
It does. Thank you.
Thank you.
Representative Bonner?
Hey, excuse me. Hey, sorry. You mentioned your
Better
organization.
run when you get a chance. No.
Right.
Yes.
You mentioned your organization. What organization is that?
That's WCCL. That's the Workers' Compensation Claimants Lawyers section of the Georgia Trial Lawyers Association, sir.
Thank you.
Okay, now you can run.
Okay, thank you, sir.
Mr. Roy?
Unless there were more trial lawyers that wanted to speak.
We might have you do.
Y'all want to arm wrestle? Who gets Mr. Roy?
Lawyers are on a roll, they can go ahead, I'll finish.
No. You want to?
I'm fine, Mr. Chairman.
And Ms. Parker, sorry I was rushing you. I was looking at the clock, and then I realized nobody was outside to come in the room, so just need to be somewhere around 6. No.
Well, thank you, Mr. Chairman and members of the committee. My name is Roy Bowen. I'm the president of the Georgia Association of Manufacturers, but I'm also honored and privileged to serve as the chairman of the Advisory Council to the State Board of Workers' Compensation. I think Representative Kirby made some fine arguments
in support of Mr. Potter's suggestion that this bill not be acted upon. I won't recite those and repeat those. I will simply say that this substitute is a solution in search of a problem. It's not necessary and undercuts for what has been better than 2 decades, a process that has very well served the state, the injured worker, and the employers of this state. I will tell you that in our view it also conflicts with existing statute in 34-940 that says the board shall have full authority, power, and the duty to promulgate policies, rules, and regulations for the administration of this chapter. I will tell you that it is not the intent of the Advisory Council, nor has it ever thought that its role was to enact law, nor has it done so. This substitute is contrary to the unanimous vote of the Advisory Council that suggested that the concerns raised by Representative Kirby could be handled by rule. And that rule has been promulgated, not promulgated, but drafted. It's been in the hands of the chairman, and it's been in the hands of Representative Kirby. It addresses, we believe, substantially all the concerns that have been raised by Representative Kirby. This legislation and this substitute and the bill that it substitutes for is opposed by 25 associations and organizations that represent virtually every part of Georgia's business community. The concerns raised by Representative Kirby have been addressed by the draft. As far as I know, the only group that's supportive of this legislation or the substitute is a fraction or a part of the Georgia Trial Lawyers Association. This substitute imposes a cumbersome process in place of one that has served this state very well. It will, without doubt, further politicize a system that does not need politicization. And we ask that you not pass it. Thank you very much for your kind attention.
Who was first? I think, Ms. Doreen, you were first. Representative Carter.
Okay, I actually, my question was more toward the comment that you you made. So, from the testimonies that I've heard and the concern that I think I'm hearing from Chairman Kirby, as it relates to this legislation, is when does a rule become a law? And if the advisory committee is inadvertently passing laws that they're calling rules. And are you saying that the proposed rule that you all agreed to addresses that, and you do not believe that this piece of legislation that we're considering addresses whether or not the advisory committee has inadvertently passed a law?
Well, Representative, thank you for that question. I want to stress the Rules Committee nor the Advisory Council passes laws.
Right.
The rules that are put into place implement or address oftentimes legislation that has been passed by this General Assembly. The General Assembly has every right at any time to pass a law that would reverse a rule that that has been suggested by the Advisory Council. Now, I have to say this. We serve as the Chairman's Advisory Council. This council is an advisory council. We give recommendations to the board. It's up to the board as to whether they accept or reject those recommendations. But most of the time, because of the composition of the Advisory Council, 110 folks who are intimately involved with the workers' compensation system, the recommendations that come by the Rules Committee, Legislative Committee, the Rehabilitation Committee, the Medical Committee are well thought through and are generally accepted. Now, as the current rule and the proposed rule provides, the chairman of the House Insurance and Labor, or the House Industry and Labor Committee and the Senate Counterpart Committee will get copies of these proposed rules. If there's a problem or an objection, they will be subject to a public hearing. But I want to stress again, this advisory council does not make law. We respect the fact that it's your view, it's under your purview to make law. That is not our role.
Thank you.
Yes, ma'am.
Representative Jones, hold on, Mr. Bowen. I don't know if these are for you or for Mr. Todd Jones.
Thank you, Mr. Chairman. Mr. Bowen, I'll be honest with you. I've been over here kind of going back and forth and vacillating based on what's happening. Anytime someone tells me 120 people were unanimous, it gives me I think of AT&T and the airlines back in the early 70s. They were all unanimous that breaking them up was not a good thing. And I'd like to think that innovation in telecom and innovation in aviation, I think, has brought us to know that that breakup was a good thing. Obviously, we're not talking about the deregulation of you guys, but rather that one kind of spooked me a little bit, to be completely frank with you. But I'm looking at 34940 right now. It's the geek in me. And because just prior to you, the previous speaker had indicated that you guys had not been set up via code. I don't know if you heard that or not. The gentleman before you, and I apologize. I didn't catch his name. Can you please give me that site one more time? Because I have 34940, and I can't find the language that you're referring to that we've given that authority to this rule to
yes,
you.
Yes, it's 34940, Article 2 under administration. It's about halfway down the paragraph.
Okay.
The State Board of Workers' Compensation created appointment of members, powers and duties of board generally. I'd be happy to read it again if you'd like.
Yeah, could you please?
Yes, sir. It says, the board shall have full authority, power, and the duty to promulgate policies, rules, and regulations for the administration of this chapter.
Okay, thank you. I have it now. I apologize. I couldn't find it, and it was giving me a little bit of a pause.
That's all right.
I appreciate it, Mr. Bowen. Thank you.
And just in response to your coming together with unanimity was not an easy task. I want to tell you that this has been an issue that's been discussed hours upon hours upon hours. But at the end of the day, at that meeting in St. Simon's, there was no objections to moving forward with a rule and with the idea that we did not need legislation.
I understand. Every day I try to explain to my constituents, you'd be surprised how many times when you look up on the board after a vote, it's, 165 to 1. So I get it.
Great.
You waiting? Representative Hawley.
Yeah. Curious. Mr. Bowen, when was this discussed? You said in St. Simon's?
Yes, the meeting in October. The advisory council meets annually.
Okay.
The committees meet throughout the year, but we come together in October. And each of the committees have work to do, and each of the committees really reports to the entirety of the council on the work of the committees.
Okay. Oh, this is one.
Mr. Park.
Thank you, Mr. Chairman. Mr. Bowen, I appreciate your testimony, and I think all of the members here appreciate the work of the advisory board and the model that under your leadership it has become. I did have a few questions just in terms of one of the assertions made where there were instances where legislative rules were passed via the back door, via the front. I was wondering if you'd be willing to address that, and also just from a structural perspective as legislators, because we're up for election every 2 years, and by God's grace, all of us will be here next year as well. But knowing that people come and go, from a structural perspective, when it comes to the rulemaking process, especially when it comes to that 10% of rules that have substantive impact on people's lives, why shouldn't there be some procedure enacted that provides for notice, public comment, and codifies what seems to be an existing process where the chairman of both the House and the Senate committee have an opportunity to have a hearing on a rule that they're concerned about.
Well, I think that the proposed rule does exactly that. It provides notice, posted on the website, opportunity for public hearing, and everything that Representative Kirby had sought. I mean, and again, if this was a system that was broken, I might not disagree with you, but it's not broken. I think what we're fixing to do is do some harm to the system.
Thank you.
Okay, I think we've exhausted all questions.
Closing comments?
Hmm?
Closing comments?
Closing comments from the author.
All right. I appreciate everybody's input that spoke for or against it. You know, we can disagree and not be disagreeable with anybody. But Representative Carter, I think, gets it. The proposed rule that I saw Monday adds some transparency, no doubt about it. It does stuff on the front end. It does not answer the then what. That's where it always stops. There's just no part of that rule that says what happens when this isn't a rule, we think it's now law. Because back in, I believe it was October, could have been November, I met with some people, Mr. Bowen, Mr. Potter, and I told him, I said, I'm okay if we come up with a rule that addresses this. And they address part of it, but they always stop it. They never address then what are we going to do when we haven't reached this as a law or a rule. Because we're not talking about rules, we're talking about law. That's all our intent's ever been. And if there was a rule proposed to me that had answered the then what, that had at least some recourse, we may not be here today. And I think we made it very clear this committee's been the most, we've asked for it. Asked for it last year, asked for it again this year. Asked for it. And we haven't gotten it. And I don't know why. You know, do I like my power so much that I just want to make rules and law and don't let anybody disagree with me? I don't know. Because we've asked and we've asked and we've asked, and we get nothing. And we get some transparency, and I'll give them that. And they're good. And does probably even more than what the statute we're proposing would do on transparency and public comments on there that we didn't put. Because we didn't want to be somebody saying this is just APA. APA has some good wording, but we didn't want to put all of it in there. But we still got to answer the then what, and that's what's never come from anybody other than what you're seeing in front of you. So I ask for your favorable support. Even if we get it out here today, we know there's still more work to do. So, but I think in the process, it is the right move to do. Thank you.
Thank you, Mr. Kirby. What's the will? I said, what's the will of the committee? Mr. Park?
It's me again.
Oh, I'm sorry. Representative.
I think, thank you. Thank you, everybody, for being here. Y'all work really hard. We thank you. I think both sides had good points. If there's a way to resolve this, because this isn't going to resolve it. The rule that they're proposing doesn't seem to quite get us there. Is there an opportunity for them to go back, try to work something out before we vote this up or down?
If you're asking that question to me, I've said all along, I'll listen to them and look at rules, and if it answers that then what, and it has a good step, we're happy to go that direction without codifying the whole thing. But I haven't got it yet.
I'm waiting. I just need a motion. If we're not, we're going to be adjourned. Last call. All right, we're adjourned. Thank you.